Ladies and gentlemen, good colleagues, good afternoon. It's a real pleasure to be part of this important discussion, albeit at distance as a result of my involvement in the annual International Conference of Privacy and Data Protection Commissioners taking place here in Hong Kong. As you know, we will be, as EDPS, the host for the next year in Brussels of these annual Olympic Games on privacy. So hectic times for the data protection world. My conclusive remarks come after what I expect to have been a dense and lively exchange on a challenging topic. You refer to a triangle in the title of your rendezvous, a triangle to describe the dynamics of modern surveillance. Let me make an initial point on this. An even better image might be the image of a prism, a three-dimensional geometric figure to illustrate surveillance, as the surveillance reality is far more complex than at first appears. A surveillance prism could illustrate how surveillance is not the sole province of state actors. Surveillance measures very often imply a high degree of intrusiveness into the private sphere of individuals. At times, this intrusion reaches an extent which might go well beyond what we would expect as necessary in a democratic society. Privacy and data protection norms require the interests and expectations of individuals to be reconciled with the need of security. The European Court of Justice and the European Court of Human Rights are setting the parameters with a number of landmark judgments in the recent years, a feeling that their lives are subject to constant surveillance is likely to be generated in the mind of the persons involved if the data are retained and used without the subjects being informed. This is what the Court of Justice said in the recent Tele2 case. So informing the data subject is key. In other words, transparency. But before transparency comes a more stringent test. Are the surveillance measures strictly necessary and proportionate for addressing the stated need? Data protection and privacy are not the only fundamental rights at stake. Freedom of expression is also crucially implied here. Can an individual who feels being subject to constant surveillance really act freely? Surveillance can pervade any aspect of our lives. For example, the well-known passenger name records agreements mean that everyday activity like air travel have become the site of general and unjustified surveillance. The same can be said of other trivial monitoring or profiling techniques. I will come back to this in a moment. However, the debate, in my view, suffers from the lack of a common understanding of what surveillance is. On the question of the legality of collection of data for security purposes, for instance, the Court of Justice has clearly distinguished between indiscriminate bulk collection of personal data and the targeting of specific categories of individuals. Personal data processed under EU law remain protected under EU data protection law, even though national security, as you know, falls outside EU competencies. These legal protections apply even when data is transferred beyond the EU boundaries to third countries. This is why we strongly support limitations to surveillance so as to prevent a generalized monitoring of all citizens. Generalized monitoring of all citizens is counterproductive in a number of ways. And I say this as a member of the Italian judiciary, years of experience on policy and legislation on organized crime. First of all, it swarms law enforcement with gigabytes of data which are useless to them. It requires fallible technological solutions for extracting valuable data. Second, it in itself creates security risks because the volume of the data which has to be stored, damaging the credibility of the law enforcement and the criminal justice system whenever a data breach occurs. And third, it diminishes trust that has been the consistent message of not only the courts but also civil society and the general public in opinion surveys. So instead of general surveillance, we need to give the police and the judiciary effective tools, training, resources, technology to perform effective targeted surveillance. In its ruling on the Digital Rights Ireland case, which invalidated the Data Retention Directive, as you know, the Court of Justice noted that the measure did not require any relationship between the data and a threat to public security. In particular, the ruling was very critical of the fact that the legal regime was not restricted to retention in relation only to a particular time and geographical zone. Digital Rights Ireland was also very critical of retention not being limited to only those persons contributing to the prevention, detection or prosecution of serious offences. And in response to these developments, we published as EDPS a toolkit for assessing necessity of surveillance and other intrusive measures earlier this year. The toolkit was conceived to support the legislators in implementing the necessity principle when drafting and preparing legislative measures. As I've said, surveillance is not only about public authorities performing public tasks for national security and safety purposes. Monitoring of people can be, though, different means. Monitoring by non-state actors should not be overlooked. The European Court of Human Rights has also made an important contribution, especially on the monitoring of electronic communications performed by an employer. Commercial surveillance is also relevant. Our digital economy is characterized by constant and often covert tracking of individuals' activities online, something we would never accept in the real world. So the General Data Protection Regulation will, in my opinion, address the harms to the individual posed by profiling, for example. So to conclude, the surveillance triangle or prism, as I said, or whatever you call it, is a complex phenomenon. Public authorities are bound by obligations to uphold the principles of transparency, necessity, and proportionality. Individuals are entitled to withhold consent to monitoring by private actors, whether in a sectorial context such as employment or as part of a broader business model based on covert tracking. On EU our EU surveillance prism is further complicated by at least one further element, which is the lack of specific EU competencies when it comes to pure national security and safety. So a patchwork of different national approaches persists. And this means we still have no clear EU approach to understanding the range of the admissible surveillance and monitoring of data subjects by public authorities on grounds of national security and safety. What is at stake here, to adapt the words of Aldous Huxley, is the basic right not to be subject to the unforeseeable consequences of a digital dystopia. The data protection principles, luckily, are elaborated in the European case law to help to complete a sustainable framework for security policies, which respect the rights of individuals. Perhaps this is not enough, but it's something to consider. Thank you for listening, and thank you for inviting me to join this event.